Thank you. Thank you for that very nice introduction, Clay. Thank you to the Diversity Committee for organizing this event. It's nice to be here. The first time I was in Washington State was about 27 years ago, the summer before I went to law school, and I was hitchhiking from Seattle to Salt Lake City with a friend of mine in the back of a pickup truck when we looked over and we saw this big smokestack, and it kept growing higher and higher and higher, and it was Mount St. Helens going off. So that was 27 years ago. Then I didn't come back for about a dozen years. I came back 15 years ago, about 3 weeks before I was to get married, with my wife and another couple, and we were going backpacking in the Cascades mountain range. And on our first day out, we were caught in a whiteout snow blizzard, and the second day we were crossing a kind of straight up and down ice field, and roped together, fortunately. And first I fell, and then my friend's wife fell, and then my friend who was leading the expedition decided maybe we weren't up to it, and we left and went somewhere a little bit safer. So I feel relatively safe this time. Bola drove me here from the airport. That was a little scary, but other than that, I have a lot of microphones on here. I understand that, a couple of years ago, John Ashcroft came and spoke here and insisted that he not be taped at all. His position is that he wants to tape you, but you can't tape him. All right. This is not the first time that the United States has faced a threat of terrorism leading to acts of horrific violence. In an earlier stage in our history, 1919, we were confronted with similar acts, not of the same scale, but similar acts. 1919 was a period of substantial crisis in the United States. There was the war had ended, the veterans had come home, there weren't jobs available for them, there were strikes across the country, many of them turned violent. The communists had taken over the Soviet Union, and all of this culminated on a single day, within the same hour, in 8 different cities. In the summer of 1919, bombs were set off. One of them blew off the front of the private home of the Attorney General of the United States in Georgetown, Washington, D.C. A. Mitchell Palmer was his name. And we responded to that series of attacks and that threat in a way that I think is illustrative of the way that we have responded to the attacks of 9/11. The government did not go out and find the bombers and bring them to justice, but instead went out and rounded up thousands of foreign nationals in coordinated raids carried out in 33 cities across the country, locked them up, denied them access to lawyers, interrogated them coercively, and ultimately ordered many of them deported, not for any involvement in the bombings. No bombers were actually ever brought to justice, but instead on charges of technical immigration violations and guilt by association with one or another branch of the Communist Party. And writing about this period after the fact, Louis Post, who was a real hero of the time, he was the Secretary of Labor, which at that time was in charge of immigration, and he actually stepped in and overturned many of the deportation decisions because he felt that these so-called Palmer raids were so problematic, and was ultimately called up on impeachment charges for doing so. He wrote a book about this period, and he said that the delirium caused by the bombings turned in the direction of a deportation crusade with all the spontaneity of water seeking out the course of least resistance. With all the spontaneity of water seeking out the course of least resistance. And what he meant by that, of course, was that the reason that the government singled out foreigners and rounded up foreigners was not because there was evidence that foreigners were the bombers, but because they could. Because they could employ tactics like guilt by association, because they could deny people access to lawyers, because they were them and not us. And I think in the wake of September 11th, again, we have seen our government pursue this course of least resistance. And in a way, it's understandable. You know, one of the things that democracies do, democracies are good at a lot of things, but they're not very good at protecting those who are not in the majority. And it's very tempting when the majority is threatened to try to figure out some way to reassure itself, not by sacrificing its own rights for greater security, but by sacrificing somebody else's rights for greater security. And that's, in fact, what the Bush administration essentially laid out to the American people. They said, you don't have to give up your rights for a promise of greater security because we've got a better deal. We'll take away their rights, they being foreign nationals and especially, of course, Arabs and Muslims, for your security. So what I want to do this evening is just sketch out the multiple ways in which this double standard has been exploited in striking what I think is an illegitimate balance between liberty and security. And then I want to make 3 points about this tactic, this exploitation of double standards. First, that it's wrong as a normative matter. Second, that it's a first step towards the evisceration of rights of all of us, including the citizens among us. And third, that it's counterproductive as a matter of security. So first, let me review for you the ways in which these double standards have been employed. I think you really have to start with what I call the Ashcroft raids. You know, in reference to the Palmer raids. After 9/11, John Ashcroft made a speech in New York in which he said, I am going to use every law within my power, especially immigration law, to lock up suspected terrorists, keep them off the streets, and prevent the next terrorist attack from occurring. And he did. In the first 2 years after September 11th, according to the government's own admitted numbers, over 5,000 foreign nationals were locked up in preventive detention immigration measures. Over 5,000. Many of these people were locked up in the first couple of months after 9/11, as the FBI and the INS swept out and picked up people on no charges or on immigration charges, on some, not on any strong basis that they were involved in terrorism, but on some concern. The Office of Inspector General of the Justice Department did an investigation of this roundup after the fact and found in its report that the people were locked up on such information as an anonymous tip received by the FBI that there are too many Middle Eastern men working at the convenience store down the street. That was the information they get. And now before 9/11, they get that kind of information, they'd say, thank you very much, hang up the phone and go back to their work. But after 9/11, what they did was they sent out the FBI to the convenience store, lined up the Middle Eastern men who were working there against the wall, and if they couldn't rule out that they were terrorists, they locked them up. They locked them up. And they were then part of the statistics that John Ashcroft used when every time he got on television and said, we've now locked up 800 suspected terrorists. We've now locked up over 1,000 suspected terrorists in the 9/11 investigation. He stopped giving a number after it reached about 1,100, and people started saying, how come none of these people have been charged with a terrorist crime? So then they announced, well, it's too hard for us to count how many we've locked up, so we're not going to tell you a number. But over the first 2 years, it was, by the government's own admissions, over 5,000. Many of these people were picked up and locked up without charges. So you're picked up off the streets of the United States, you're thrown in detention, and you say, why am I here? And there's no answer, because there's no charge. They locked them up first, looked for a charge later. They were arrested in secret. So a woman could find that her husband has not come home that night, and she could call the local police, she could call the FBI, she could call the INS and say, do you have any record of my husband? He's disappeared, he hasn't come home. And the answer would be no, even if he was sitting in jail right behind the man on the phone, because the arrests by order of John Ashcroft were all secret. Many of them were eventually charged with some sort of immigration violation, taking too few credits on a student visa, working without authorization, overstaying your visa, things like that. And all of those were tried in secret trials, closed to the public, closed to the press, closed to members of the family, closed even to members of Congress. John Conyers, the representative, now the chair of the Judiciary Committee, sought to attend one of these hearings in Detroit, and he was barred at the door. Many of these people did, in fact, violate their immigration status, and agreed that they violated their immigration status, and were allowed by the judges in those cases to leave. We're told you can leave. Ordinarily, that would be the end of the case, because the only legitimate purpose of an immigration case is to remove people who are not properly here. But when your purpose is not to remove people who are not properly here, but to lock up people who you suspect but have no evidence of engaging in some sort of terrorism, it's a problem if they agree to leave. And so the administration adopted a policy called hold until cleared, under which you were not allowed to leave the country, even if you agreed to leave, until the FBI satisfied itself that you were not, in fact, involved in terrorism. That took the FBI, on average, about 3 months, in many cases, more than 6 months. And people just sat in jail on no probable cause that they'd ever committed any criminal activity, and for no legitimate immigration purpose, because they'd agreed to leave the country while the FBI investigated them. Now, the government could not get away with this if these people had been U.S. citizens. It used immigration law to do it, and if it had locked up 5,000 American citizens without charges, in secret, giving them secret trials and the like, there would be massive public consternation. Because they were foreign nationals, we sat silently by. Guantanamo, where we have now held people for more than 5 years without any trials whatsoever. The government defends Guantanamo by arguing that because the people held there are foreign nationals, because they're foreign nationals and they're outside of our formal sovereign borders, they have no rights. So whatever we're doing to them there, it can't violate any rights, because they have no rights as foreign nationals outside of our borders. The Supreme Court, over the President's objection, held that the people at least had the right to come to federal court and argue that their detention was illegal, until Congress, in one of its last acts, the Republican Congress in 2006, enacted the Military Commissions Act, which stripped the federal courts of any habeas corpus jurisdiction to review the legality of the detentions of the people at Guantanamo. And last week, the D.C. Circuit held that that was indeed what Congress had done, and that there was no problem with Congress doing that. Why? Because they were foreign nationals held at Guantanamo, and therefore they had no constitutional right to habeas corpus in the first place. So what Congress gave, Congress could take away. The government makes the same claim when it defends the treatment of people in the CIA's black sites. the secret prisons into which quote-unquote high-value al-Qaeda suspects were disappeared, held for years, not only without charges and without trials, but without access to anyone, without access to the Red Cross, without access to any kind of assistance whatsoever, and where they were subjected to coercive, highly coercive, what President Bush refers to as alternative techniques of interrogation, which include, we are told, waterboarding, in which you are strapped to a board and water is poured, and a towel is wrapped around your face, your mouth and nose, and it's drenched with water so you can't breathe, and you're made to fear that you are going to drown. And the government defends those kinds of policies by contending that the international treaty that we signed and ratified that prohibits torture and cruel, inhuman, and degrading treatment, that, well, the torture part of it's not relevant because waterboarding isn't torture. And the cruel, inhuman, and degrading treatment part of it, the government argues, argued in a secret position that was only revealed when Alberto Gonzales was up for confirmation as Attorney General, and he was asked about this. They took the position that the international treaty's prohibition on cruel, inhuman, and degrading treatment didn't apply to foreign nationals held outside the United States. So it's perfectly okay to subject them to waterboarding and the like because they were foreign nationals. Maher Arar, who Professor Mosier referred to earlier, a client of mine with the Center for Constitutional Rights, was coming back from a trip, a business trip in Europe, was coming back to Canada, changing planes at JFK, when he was stopped by immigration authorities, pulled out of line, locked up for a week, denied all of his requests for a lawyer. When his family found out that he was locked up at JFK, they got a lawyer for him, and so the federal officials lied to his lawyer to keep his lawyer from actually being able to do anything on his behalf. He was ordered deported on the basis of secret evidence that the government claimed showed that he was a member of al-Qaeda. He denied that he was in any way associated with al-Qaeda, but of course he couldn't see the evidence, so he couldn't respond or rebut it. And then the government said, well, you're going to be deported. And he said, well, you know, actually, I didn't really want to come to the United States anyway. I was just changing planes, and here's my connecting flight coupon to Canada. And they said, oh, no, you won't need that connecting flight coupon because we've chartered a federal jet for you, and they took him to Syria. And you got to ask yourself, why would the United States take a Canadian, stop him at the border, at JFK, and redirect him to Syria, except for the fact that Canada doesn't have a record of locking people up arbitrarily and torturing them, and Syria does. And that's what Syria did. And then Syria released him after a year because they found no evidence he was involved in any kind of illegal activities whatsoever, even after they tortured him. He was sent back to Canada, where last year Time Canada named him Person of the Year. Time USA named George Bush Person of the Year. So Time seems a little, caught up in this war on terror too. And where, as Professor Mosier indicated just a couple of weeks ago, the Canadians completed an official inquiry that cost $10 million and concluded that he was wholly innocent, exonerated him, apologized, and paid him over $10 million as a settlement for his wrongs. But what's the United States' response to Mr. Arar? And it wasn't the Canadians who sent him to Syria, and the Canadians are paying him $10 million. When we sued John Ashcroft, I don't know why John Ashcroft's name keeps coming up here, but when we sued John Ashcroft and others who were responsible for sending him to Syria, the United States position was, he doesn't have any rights. No rights were violated. Even if we sent him to Syria to be tortured, no rights were violated because he's a foreign national. And he never actually entered the United States. You know, JFK, if you go to JFK, I don't know how many people have been to JFK Airport, it does actually look like a third world country, JFK. And it's a very kind of odd airport, but it is in the United States. But the United States theory is, well, he didn't ever actually formally enter the United States, therefore he has no constitutional rights, therefore no rights were violated. We can do it to him because he's a foreign national. Military tribunals. The president, in November of 2001, issued a military order number 1, which set up military tribunals in which people could be tried and executed on the basis of evidence obtained through torture and then introduced in secret that they could not see or confront. And who did that set of procedures apply to? It applied to foreign nationals accused of terrorist crimes. Not to Americans accused of terrorist crimes, but to foreign nationals accused of terrorist crimes. And there's no legal reason why it should be limited, why military tribunals should be limited to foreign nationals. We've applied them in the past to US citizens. We did so as recently as World War II, and the Supreme Court upheld it. The reason was political. Dick Cheney got on television and said, when a foreigner comes and attacks us, he doesn't deserve the same rights and guarantees as a US citizen. So again, you see that double standard. It's not your rights we're taking away, it's their rights. The Patriot Act. You know, we've heard a lot about the Patriot Act, but the worst provisions of the Patriot Act you probably didn't hear about. They were provisions that allowed the government to keep people out of this country, foreign nationals, based on their speech, pure speech, to deport them from this country based on innocent associations with groups we don't like, and gave the Attorney General the power to lock up foreign nationals without charges. Those are the worst provisions of the Patriot Act, but you don't hear about them because they're not the ones that directly affect citizens. Final example, ethnic profiling. I think we've seen in this country the most extensive national campaign of ethnic profiling since 9/11 that we've experienced since World War II. Since World War II. And you know, World War II was worse. World War II, we locked up 120,000 people, Americans and immigrants alike, simply because they had Japanese ancestry. Simply because of their Japanese ancestry. We didn't do that this time around. But we did lock up 5,000, and virtually all of them were Arab and Muslim. We did call in 8,000 for FBI interviews solely because they were young men from Arab and Muslim countries. No other reason. And we did call in 80,000 for so-called special registration, again, simply because they came from Arab and Muslim countries. And when the administration was challenged that these kinds of tactics, focusing on people for little more than the fact that they are Arab and Muslim, too many Middle Easterners working at a convenience store, Arab or Muslim, you come and register. Michael Chertoff, who's now the Secretary of Homeland Security, but at the time was in the Justice Department, testified in Congress, and he said, "We do not engage in ethnic profiling." Next sentence, what we do is target foreign nationals based on country of passport. Well, so again, you see, it's okay because we're doing it to them, to foreign nationals, not to us. Now, you know, some of these initiatives have gotten a lot of attention. Some of them have sparked significant protest. I would say most of them much more protest outside this country than inside this country, but nonetheless they've sparked some protest. But look at what happens when the United States government says after 9/11, you know, we think you should sacrifice your rights for a promise of greater security. It's not that we're going to take somebody else's rights for your security, but we want you to give up your rights. We want everyone to have an ID card. It's not a big sacrifice in rights. Everyone should have an ID card. That was sort of, you know, that trial balloon was put out there after 9/11, And what happened? Congress in the Homeland Security Act said no federal funds shall be spent on creating a national ID card. Until the Real ID Act, when they said, let's have IDs for foreigners, not for Americans. So when Americans were asked, how about if we all carry an ID card, we said, no, we don't want to give up our rights for security. We'll give up somebody else's, but not ours. Similarly, when the Justice Department came up with the program Operation TIPS, where it was going to go out and recruit 11 million of us to spy on the rest of us and inform the FBI, we didn't like that idea, that our neighbors would be snooping on us and calling the FBI. And so, again, Congress in the Homeland Security Act said no funds shall be spent on Operation TIPS. Then you had John Poindexter's idea in the Pentagon that we would create a huge computer database in the Pentagon that consisted of all the computerized information that exists out there about us. And you know, virtually everything you do these days creates some computer record. When you registered for this lecture, you know, that created a computer record. When you buy something with a credit card, when you surf the web, when you send an email, when you make a phone call, when you make a travel reservation, when you register for your classes, all of that creates computerized data. And John Poindexter's idea was, let's gather all that information and analyze it 24/7 in the Pentagon, and maybe we'll find some terrorists. And that program was whirring right along until the Pentagon PR department had the brilliant idea that they would call it Total Information Awareness, that they would create a logo for it which consisted of a pyramid with a big eye on the top, except the eye, it's on the back of your dollar bill, except the eye is digitized. It's like a computer eye. And then over that they wrote, knowledge is power. And lo and behold, Americans didn't like that idea, that the Pentagon was engaging in this kind of George Orwell, Michel Foucault kind of tactic, and we killed it. When the United States declared Jose Padilla, an American citizen captured at O'Hare Airport, an enemy combatant, and said it could lock him up without charges indefinitely, every newspaper in the country, as far as I could tell, maybe not the Wall Street Journal, but every other newspaper editorialized against this. Lock up an American citizen without charges, without trial, without access to court, without access to lawyers? But who's heard of Mr. Almari? How many have heard of Mr. Almari? One. Mr. Almari is in the same position as Mr. Padilla. He was arrested in Illinois. Somehow Illinois, my home state, seems to be a breeding ground for suspected terrorists. He was arrested in Illinois, declared an enemy combatant, and has been locked up without charges, without trial, in a brig in South Carolina, the same brig that Jose Padilla was in, for 3 or 4 years now. Nobody's heard of him. Why? Because he's a foreign national, not an American citizen. So we've seen these double standards throughout in the way in which we have responded to 9/11. Now, I want to make, as I said, 3 points about it. First, that it's morally and normatively wrong. Second, that these kinds of steps are first steps toward eviscerating the rights of citizens as well. And third, that it's counterproductive. First, that it's wrong. It's not wrong to acknowledge that Al-Qaeda attacked us and that Al-Qaeda is made up of Arab and Muslim foreign nationals. That's not wrong. That's not a stereotype. That's fact, right? But what's wrong is to deny foreign nationals basic human and constitutional rights, no matter who they are. There are some rights in the Constitution that are explicitly limited to citizens. The right to vote, protected by the 15th Amendment, the privileges and immunities clause in the 14th Amendment. The right to run for elected office, federal elected office, is limited to citizens. But that's about it. None of the rights in the Bill of Rights are limited to citizens. Not the First Amendment, right to free speech, not the Fourth Amendment, right to privacy, not the Fifth Amendment, right to due process and privilege against self-incrimination, not the Sixth Amendment, right to a public trial, not the Eighth Amendment, right against cruel and unusual punishment. These rights are not termed as rights of citizens, but rights of persons, of people, of the accused. Not limited. And the reason for that was that when these rights were created, recognized, the sort of broad understanding of rights was that they were God-given, divine rights, natural law rights. God gave them to us. And God didn't give them only to people with American passports. Today, we have international human rights treaties that the United States was actually a leader in spearheading. The International Convention of Civil and Political Rights, the Universal Declaration of Human Rights, the Inter-American Convention on Human Rights, all of these are predicated on the notion that rights, certain basic rights, like due process, like free speech, like the right against arbitrary detention, like the right to equality, are rights that stem from human dignity. And we don't have any monopoly on human dignity. Shortly after 9/11 in Great Britain, the Parliament adopted a law that said that suspected terrorists who were foreign nationals could be locked up indefinitely if they couldn't be deported. And 2 years later, the law lords, which is the equivalent of our Supreme Court, held that that law violated the European Convention on Human Rights. Why? Precisely because it discriminated between foreign nationals and British nationals. The law lords reasoned, if a British national is a suspected terrorist, we don't lock them up indefinitely, and we're able to survive without locking up British nationals indefinitely on the grounds that they're suspected terrorists. And therefore, it can't be justified to lock up foreign nationals as suspected terrorists. If we can live with the British nationals, then certainly we should be able to live with the foreign nationals as well. There's no justifiable ground to distinguish between foreign nationals and citizens with respect to basic rights like the right to liberty. So that's the first argument. It's wrong. The second is that what we do to foreign nationals in the name of security creates a precedent for what will be extended to citizens. Go back for a moment to the Palmer raids, with which I opened, where those thousands of foreign nationals were rounded up. The architect of the Palmer raids was not Attorney General Palmer, for whom history has given them their name, but rather a young lawyer just a couple of years out of George Washington Law School, who first job in the Justice Department during World War I was regulating enemy aliens, and whose second job was to head up something called the Radical Alien Division of the Justice Department. No, not the Radical Division of the Justice Department, the Radical Alien Division of the Justice Department. And he came up with the idea. His name was J. Edgar Hoover. He spent the next 50 years of his life as the head of the FBI, and spent all of that time seeking to extend the tactics he had successfully, quote unquote, employed against foreign nationals in the Palmer raids to US citizens. And in the McCarthy era, he succeeded. Some historians say it really ought to be called the Hoover era, not the McCarthy era, because that was when we extended the principle of guilt by association from foreign nationals, where it was first employed, and employed quite aggressively during the Palmer raids, to thousands upon thousands of US citizens. The Japanese internment of World War II, in which American citizens as well as Japanese immigrants were locked up, was but an extension of the enemy alien laws, which say that during a declared war, the government can lock up anyone who is a national of the country with which we're at war. You can just presume that they're disloyal because they're a national of the country with which we're fighting. Well, in World War II, we said, well, we can presume that about American citizens, too, if they are of Japanese descent. So what we do to foreign nationals is a first step towards what is done to citizens. We saw it with enemy combatant authority in this conflict, where it was first justified as we're doing it to them at Guantanamo because they don't have any rights, and then it was extended to U.S. citizens Jose Padilla and Yasser Hamdi subsequently. Finally, it's counterproductive. It's counterproductive to exploit these kinds of double standards. Some statistics. Of those 5,000 foreign nationals rounded up after 9/11, today not one stands convicted of a terrorist crime. Of those 8,000 called in for FBI interviews, not one stands convicted of a terrorist crime. Of those 80,000 brought in for special registration because, well, you know, if we call in all the Arabs and Muslims, maybe we'll find a terrorist, not one stands convicted of a terrorist offense. So the government's record here on ethnic profiling directed at foreign nationals is 0 for 93,000. They don't have that statistic on their website, lifeandliberty.gov. I don't know why. I keep writing in and saying, put this one up, but they don't. But instead, they put up other statistics, the kind that Professor Mosier noted the Inspector General found were unsupported. But one of them is the fact that they've deported over 500 people in connection with the anti-terrorism investigation. But what they don't say is that under that hold until cleared policy that I talked about before, they wouldn't deport the person until they cleared the person of any connection to terrorism, which means that these are misses, not hits, in terms of finding any actual terrorists. And we found no al-Qaeda cells in the United States in the 5+ years since 9/11 that we have been engaged in this kind of zero tolerance policy directed at the Arab and Muslim foreign national community. But it's not just that there isn't a whole lot to show for it in terms of terrorists captured, brought to justice. It's worse than that. These kinds of double standards are what fuel the anti-Americanism that we see so prevalent throughout the world today. On 9/11, we had the world's sympathy. Today, anti-Americanism is at an all-time high. Never before in the history of this country have there been levels of anti-American sentiment as high as they are today. And if you look at what is it that they're complaining, what is it that has made them, made the world so resentful towards the United States? It's this attitude that we don't have to play by the same rules that you have to play by. That we can impose on your citizens burdens and obligations that we wouldn't be willing to bear ourselves. And that kind of attitude then gets extended to things like the war in Iraq, where we can go to war for reasons that no other country in the world is permitted to go to war. And we can have a president who says, we're fighting them over there, meaning tens to hundreds of thousands of foreigners' lives being sacrificed, so that we don't have to fight them over here, when there's no evidence that they were coming over here to fight us, the people in Iraq, that is. And when a country exploits double standards, when a country is not willing to play by the rules that everybody else is willing to play by, it sacrifices the legitimacy of its enterprise. And the enterprise of trying to keep us safe from another terrorist attack like that which we suffered on September 11th is a wholly legitimate enterprise. And I don't think anybody, any rational person could deny that. But if you pursue a legitimate end through illegitimate means, then you sacrifice the legitimacy of your enterprise. And when you do, it has at least two negative consequences. One, it makes potential allies less likely to want to cooperate with you because you're seen as untrustworthy, as illegitimate, and the like. And so by targeting Arabs and Muslims, and particularly Arab and Muslim foreign nationals, we send a message to the Arab and Muslim communities around the world, the ones whose help we need most if we're going to find those few who are actually terrorists trying to attack us. We send a message that says, don't come to us, because if you come to us, we may lock you up. And at the same time that you push away those communities that you need to work with most, you give to the enemy, to Al-Qaeda, the very propaganda that it most wants to exhort its supporters and its recruits to keep fighting against us. And so we have undermined our security by employing these double standards. We have gone the first step towards undermining our own liberties. And I think we have undermined our character by engaging in tactics that are normatively and morally and constitutionally wrong. Let me close with a quote. I use this quote as the epigraph for my book, Enemy Aliens. It's a commentary not on the Constitution but on the Bible, but I think it applies nonetheless. It's by Herman Cohen, a Jewish philosopher, who wrote, "The alien was to be protected, not because he was a member of one's family, clan, or religious community, but because he was a human being. In the alien, therefore, man discovered the idea of humanity." The question I think we face in the wake of September 11th is, can we rediscover that idea of humanity? And I think only if we do so can we be both safe and free as we go forward in the 21st century. Thank you very much. Thank you. I'm happy to take questions. Yes?
I'll take a stab at this. You're a law professor, and I'm not, so really, but my question is, the arguments that you're trying to make, you made your final arguments on the basis of granting, acknowledging rights to non-citizens on the basis of moral columns. And I'm wondering if these are the kind of arguments that you could bring into a court of law like the Supreme Court, or whether there's more legal reasoning, whether you bear on these international treaties or human rights. Where is it that you make a legal case on this as opposed to simply a moral case?
Yeah. Well, that's a good question, and I think there's a legal and a moral case, and I think it's not always the case, but in this case they actually go hand in hand. And the legal case for constitutional rights is the textual case that I made. I mean, I actually made a legal case before I made a moral case, which is that if you look at the Constitution, it uses the term citizen with respect to some rights. It uses the term person, people, or the accused with respect to other rights. They must have meant something by the difference. The presumption is that what they meant was that the rights that they talk about with the broader terms like persons apply to all persons. And indeed, the Supreme Court has accepted that. It held in a case in 2001, for example, that all persons within the United States are protected by due process, whether they're foreign, whether they're citizen or alien, whether they're here legally or illegally. Now, I would go further and say all persons, whether they're here or not, are protected by due process when the United States exerts its sovereign authority over them, when it locks them up and the like. But the Supreme Court has recognized that person means person, not just citizens. And I think it's also a legal argument to point to the fact that when this language was drafted, the natural law underpinnings of divine rights were not something that would be limited to Americans under any sort of conception of natural law. God gives it to people because people are made in His image. We don't, not many people buy the natural law theories anymore, but it reflects what the framers understood when they devised these legal rights in the Bill of Rights. And then I think the human rights treaties are a kind of modern day version of that, the notion that rights are predicated not on what passport you have, but based on human dignity. That's the fundamental predicate of all human rights, and that doesn't really permit for distinctions between foreign nationals and citizens. And so those are legal arguments. I mean, I also think there's a moral case to be made, and I think there's a political case to be made that you want to. That one of the best ways of ensuring that we don't overreact to times of crisis is to require that any measures we employ are generally applicable. So I'm, for example, a lot less worried about the kind of increased security at airports, which some people think is not enough, some people think is too much. But to me, the thing about airport security is it affects all of us, right? We all have to go through it. And so we all have a stake in making sure that the balance is right. And the political process will take those concerns into account. Whereas if we devise methods like military tribunals and Guantanamo detentions and renditions that apply to foreign nationals and not citizens, then nobody who has a vote, who has a voice in the political process, has their own liberty interests at stake, and the process is inevitably going to come up with a skewed result. So, I think there are many arguments beyond moral arguments that one can make. This is actually going to be a huge issue, whether when the Guantanamo cases get back up to the Supreme Court, this is going to be a huge issue, which is what rights, if any, do the Guantanamo detainees have? The administration's position is none. But I'll be surprised if the Supreme Court adopts that sort of blanket approach.
Let me just follow up real quickly and say that those of us who travel abroad would not want our rights to disappear the moment that we set foot outside of our country as well.
Yeah, well, that's good. And actually, in the early days, there was this kind of territorial understanding of rights, so that even if you were a citizen, if you were outside of our borders, you were not protected by the Constitution. But in the 50s, the Supreme Court rejected that and said, no, it doesn't, the Constitution follows the citizen wherever he goes, or he or she goes. And so if the United States government does something to a U.S. citizen in Germany, it's bound by the Constitution. My view is if the United States government does something to a German citizen in Germany, it ought to be bound by the Constitution. The United States government's authority derives from and only from the Constitution, and the Constitution sets limits on that authority, and those limits ought to apply whether it's acting, in Mississippi or whether it's acting at Guantanamo.
So, this gentleman over here,
Yeah.
I hope this will be an understandable question. As a survivor of another period in our country when we did not know who the enemy was, fundamentally, and over time what happened is that everyone sort of began to become the enemy in one way or another. If you wore a uniform, if you thought certain thoughts, or didn't support certain thoughts, you became an implicit enemy and perhaps even an explicit enemy. And I'm wondering, how long can this country endure a situation where we don't know who the enemy is, really, specifically, which is why we're trolling so much, for one. And how long can we endure the slow malaise of more and more people becoming the potential enemy? What do you think that'll do to the law?
Yeah. Well, I think, that historically what's happened is that measures get targeted at vulnerable groups and introduced against vulnerable groups, and then they do get extended through a kind of mission creep to broader and broader groups. And so, you know, you see the anti-communism, for example, starts out as an anti-immigrant measure, gets extended to U.S. citizens in the McCarthy period in something called the Alien Registration Act, but it applies to citizens as well. When it gets struck down by the courts after McCarthy is censored by the Senate, the trolling for communists continues, but sort of in an underhanded, underground way by the FBI through things like COINTELPRO, where they were, you know, they were spying on anti-war groups, environmentalist groups, civil rights groups, Dr. Martin Luther King Jr., all on the theory that, well, there might be communist infiltration into these groups, and so we've got to infiltrate these groups, and we've got to surveil these groups to find out if there is, right? And the broader it got, the more people, the more, you know, the broader the public concern about it was, because the more people who you knew were affected by it, and ultimately it reached a broad enough segment of the American populace that there was a reaction against it, and we, you know, put in place various reforms in the 70s that were designed to try to restrict those kinds of risks. So there is a way in which I think the broader it gets, the more politically unstable it becomes, and the more opposition will come. I will say, though, that, you know, that's kind of a very long view, and that's not very satisfactory for those of us who only live in the short term. But I will say that I think there is, you know, some substantial reason for optimism or hope about sort of where we're going with all of this, in the sense that, you know, I think if you had predicted, you know, on September 12th, you know, after the most powerful country in the world had been attacked by a group that was willing to engage in the sort of most horrific act of terrorism that the world had seen, if you had said, well, you know, the most powerful country in the world is not going to be able to get away with whatever it wants to in trying to make itself secure from this horrific group, people would have said, well, you're crazy. Who's going to stop it? Who's going to stop the most powerful country in the world? Who's going to stand up for these obviously, you know, very evil, as Bush puts it, terrorists who would do what was done on September 11th? And I think, you know, what you see 5 years later is that, in fact, the American government has had to backtrack on virtually every one of its initiatives in the war on terror. Iraq, right? I mean, it's not yet backtracking. The surge is not exactly a backtrack, but the American public certainly want it to, and that's why we now have a Democratic Congress. Torture. They had to rescind the torture, remember? Cruel, inhuman, and degrading treatment, the position it doesn't apply to foreigners, was overturned by John McCain in Congress in the McCain Amendment, which said that no, the cruel, inhuman, and degrading treatment law applies to everybody, everywhere. The position that the enemy combatants at Guantanamo have no rights whatsoever, and that the courts can't look into even the detention of American citizens as enemy combatants, was rejected by the Supreme Court. So the NSA warrantless wiretapping program, which the president insisted was absolutely necessary, absolutely justified, even if it was against a criminal law, he's now retreated on that and said that he's going to terminate that program, and he will carry out all future wiretapping pursuant to court supervision, not in violation of the Foreign Intelligence Surveillance Act. So on, you know, issue after issue, they've been forced to retreat. And I think that's, to me, that's encouraging. To me, that suggests that the rule of law is actually more powerful than we might have thought it was, and that civil society, when it acts to stand up for the principles that this country was built on, can in fact work to mitigate some of the damage that has been done. And I do attribute it to civil society. I attribute it to the efforts of the host of human rights groups, civil rights groups, immigrants' rights groups, grassroots organizations that have organized, have issued reports, have filed lawsuits, have spoken out for those who can't speak out for themselves and for the principles upon which this country stands when this country is at its best. And I find great hope from the fact that that set of principles and those actors have in fact forced the most powerful country in the world to back off of its position that the laws don't apply to us. The laws have to apply to us. So that's a very long-winded answer, but yeah.
Can you speak to the issue of searches without warrants?
Searches without warrants.
Yes.
Yeah.
My notion was that before we were subject to a search,
Yeah.
a warrant would have to be issued.
Yeah.
Signed off by a judge.
Yeah.
Black robe, that signals impartiality.
Yeah.
I understand that there are conditions where a warrant is not necessary now, and if that's
Well,
true, we've lost a great deal of our personal liberty.
Yeah, well, this is the National Security Agency issue where the president, Congress in 1978 said that if you want to engage in foreign intelligence and national security wiretapping, you can do so as the president, but you gotta go to a judge and make a showing before that judge that in fact there's a basis to believe that the person you're wiretapping is a foreign agent, which is a very broadly defined term. You don't have to show the person's engaged in crime. You just have to show the person is acting on behalf of or associated with either a foreign government or a foreign group or a terrorist organization. But you do have to make that showing to a federal judge, and the judge has to approve it, and that's considered a bulwark of liberty because it means that some independent person who's not engaged in this in the chase, as it were, is making the decision about whether there's a basis for wiretapping. Well, President Bush said, told the NSA, go ahead and wiretap people without warrants. You don't have to go to a judge. You don't have to make that showing. Just go ahead and do it without a warrant. And he said, I can do that because we're in a war. I'm the commander-in-chief. And as commander-in-chief, I get to determine the means of engaging the enemy. And if engaging the enemy includes tapping their phones, then I get to do that, and courts and Congress can't tell me that I have to go through some procedure and I have to satisfy some judge. I have inherent uncheckable authority to do so. Even though Congress, when it created this system, said, this is the way you do it. If you do it without a warrant, it's a crime. And if there's a war on, come to us and we'll consider whether a different standard ought to apply. The President decided not to go to Congress and instead to order that the law be violated in secret. You know, when President Nixon, during the Vietnam War, approved a warrantless wiretapping program like this, that was one of the articles of impeachment against him. And after he was forced to step down, he was interviewed by David Frost in the famous Frost-Nixon interview. Frost asked him about this. Why did you think you could, order warrantless wiretapping when it's clearly against the law? And President Nixon said, well, my understanding was if the president does it, that means it's not illegal. Now, President Nixon learned the hard way that that is not actually the American system of law, but President Bush seems to have resurrected that notion, because his notion is if the president does it and invokes the commander-in-chief clause of the Constitution, that means it's not illegal. He argued that with respect to the NSA wiretapping. He argued it with respect to the enemy combatants at Guantanamo. He argued it would be unconstitutional for Congress or the courts to in any way check or in any way review his decision to detain people at Guantanamo. All 9 members of the Supreme Court rejected that argument, but he made it. And he made it with respect to torture, where we have a federal statute that prohibits torture under all circumstances, and the Justice Department wrote a memo in August 2002, which said if the president decides that the way he wants to engage the enemy is to torture the enemy, it doesn't matter that there's a federal statute that makes that a crime, because the president cannot be checked, literally cannot be checked by the other branches when he's acting as commander-in-chief. So that's the, it's not just about warrants, it's about a notion of presidential power that says separation of powers no longer plays a role. Yeah.
I wanted you to go into a little bit more detail on the groups and individuals that have provided this opposition, like the Center for Constitutional Rights and the American Civil Liberties Union and other organizations that have been a part of that civil response to try to defend the country. Well,
I think that one of the things that my bases for hope and optimism is to think back to the last major crisis of this kind in this country, which was the McCarthy period, and ask, what was civil society doing then? And there were many fewer nonprofit organizations out there of citizens organized to stand up for rights and the such. But the ACLU existed. The ACLU existed. And what was the ACLU doing during the McCarthy era? It was purging itself of communists. Its view was communists didn't have a strong enough commitment to free speech. So what we got to do, while the government is harassing people for their political beliefs, we've got to harass people for their political beliefs. That's what the ACLU was doing. And there were two organizations, the National Lawyers Guild and the National Emergency Civil Liberties Community, that defended those people who were targeted as communists, and they were red-baited as communist front organizations for doing so. Now fast forward to today, where you have the ACLU has been doing, I think, a tremendous job in educating the public, in filing lawsuits, in lobbying Congress on behalf of these very, very basic rights. But it's not alone. There are a host of organizations out there that didn't even exist 50 years ago. The Center for Constitutional Rights, with which I work, which is the group that brought the Guantanamo lawsuits, didn't exist back in the 50s. All of the human rights groups, Human Rights Watch, Human Rights First, Amnesty International, didn't exist. The internet privacy groups, Electronic Privacy Information Center, Center for Democracy and Technology, the immigrant groups, American Arab Anti-Discrimination Committee, the religious-based groups, the Council on American Islamic Relations. Each of these groups, they didn't exist back then. They do exist now. They're strong. They're relatively sophisticated. They work together on a number of these issues, and they each have a website. They provide, most importantly, they provide opportunities for us, for all of us, to get involved, to get informed, and to speak out. One of my favorite is the Bill of Rights Defense Committee, which is this group in Massachusetts, which had they're in Northampton, Massachusetts, and they had the crazy idea after the Patriot Act was enacted to get local towns to pass ordinances condemning the civil liberties abuses of the Patriot Act and the war on terror. And, so they went to Northampton, Massachusetts, and it took them about 3 days to get it passed. And then they went to Amherst, and it took them another, day and a half. And then they came out to Santa Monica, and they'd already passed it. And then they went to Berkeley, and they went to Portland, Oregon, all the usual suspects, and it was no problem. But today over 400 towns, cities, and counties, and I think 9 states have adopted these resolutions, and each one is each time one is put on the agenda, debated, enacted. It's an opportunity for education. It's an opportunity for outreach. It's an opportunity for networking. And it's done for the most part by non-lawyers. working together to try to stand up for very basic sets of principles using a kind of symbolic measure. And you know, it doesn't have a legal effect for the most part, but I think it has tremendous symbolic effect. And I think, you know, the true test is going to be when, what do we do after the next terrorist attack? Because there will be another terrorist attack, and how do we respond then? And I think in some ways this is a real sort of teaching moment, as you know, professors say, because we're far enough away from 9/11 that we're not sort of caught up in the panic that I think, you know, many of us felt, most of us felt right after 9/11. So we can think a little bit more clearly. We have some experience upon which to make our judgments. And so I think, you know, and yet we're not so far away that we don't care about these issues. And so I think this is the key time for people to get involved so that when there's another terrorist attack, your voice can be heard by the members of Congress as well as the voices of those who say, do whatever it takes. Because I think what the last 5 years has shown is that doing whatever it takes isn't actually all that effective in making us more secure, and may well make us much more vulnerable because of the anti-American reaction that it spawns. Do you want to go first?
Yeah, you were saying that there hasn't been a terrorism conviction of Arab or Muslim foreign nationals.
No, I said of the 5,000 detained, of the 8,000 interviewed, and the 80,000 called in for special registration.
Okay, can you comment on some of the convictions that were dressed up as terrorism convictions, but were not based on terrorism charges? What those folks were convicted of? I'm thinking of the Portland 7, for example. They were actually U.S. citizens that were convicted, and they were, John Ashcroft treated them as big terrorist convictions, yet I don't think it's clear as to what they were really convicted of.
Well, there are, if you look at the lifeandliberty.gov website, you'll see they say that they've broken up several terrorist cells. They don't say Al-Qaeda terrorist cells, but terror cells. One of them is the Portland 7, which was a group of people who pled guilty to having conspired to, after 9/11, having conspired to try to go over to Afghanistan and fight with the Taliban against us, which is not terrorism. It's treason, but it's not terrorism, right? It's a crime. It's a serious crime. But it's not terrorism. There, another group, another quote-unquote cell, are a group of 6 young men in Lackawanna, New York, who were recruited by a charismatic Al-Qaeda leader who came to Lackawanna, God knows why, and recruited these 6 young guys and got them very interested in Islam, and got them to come to Afghanistan and to go to an Al-Qaeda training camp. One of them, was so shocked that he faked an injury to get out. 3 of them left, or 3 others left early. 2 stayed for the whole 6-week thing. But they eventually all came back. The FBI knew about it. They watched them for a year very intensively, and they found no evidence that they were engaged in any sort of criminal activity, any kind of planning, even any graffiti, much less any terrorism, but were eventually arrested and charged under a statute called the Material Support Statute, which allows the government to prosecute people not for engaging in terrorism, not for supporting terrorism, not for conspiring to engage or support terrorism, but for supporting in any way a group which we have labeled as a terrorist group, regardless of the form that your support takes and regardless of the intent of that support. It's an extremely broad statute. I represent a human rights group in California that had been providing human rights advocacy training to a group of Kurds in Turkey until this law came into effect and the government designated the Turkish group a terrorist organization. And it then became a crime for my clients, a human rights group, to provide human rights advocacy training to this group, which was designed to encourage them to use peaceful means to resolve their disputes. Why? Because that's material support. And under the government's theory, it doesn't matter if your support is designed to discourage terrorism or encourage terrorism. It's support, and it's a crime. And so virtually all the terrorist convictions are under that kind of a statute. The only person who's actually been convicted of a couple people have been convicted of conspiring to engage in terrorism, Zacharias Moussaoui. Richard Reed was convicted of trying to blow up the airline by lighting his shoe. So there are a couple of cases, but as I say, none of the people who were rounded up during this 5,000 roundup, none of the people called in for interviews or for special registration.
The gentleman there and then Rose.
Okay.
Yeah, I really share the optimism you express as well as the alarm you call. I mean, I have a lot of confidence in the courts, and I know there's a lot of good organizations that I think we can count on to defend the liberties. But I was really surprised, maybe I'm naive, but that Congress is doing, I thought, such a weak job of re-examining the Patriot Act. They took out a couple of things, but they left in lots of them. And politically, apparently, they felt this is safe to do. I'm disappointed there weren't some leaders there that would really point out some of the dangers and the hazards, as well as the fact that the Patriot Act hasn't really accomplished very much.
Right. No, I agree with that. I mean, it's not the Patriot Act reauthorization was very disappointing, as I think, and even more so, this Military Commissions Act, which was enacted, at in October after the Supreme Court decision this summer. Both of them are very, very, very disturbing. And the question really is, now that we have a Democratic Congress, will there be any more backbone? And I'm not sure that there will be, actually. And my optimism does not rest in Congress, I'll have to say that. And I think that's in part, I've been doing anti-terrorism, civil liberties stuff for 20 years. And I, started doing these kinds of cases when President Reagan was in office, and did them under first President Bush and President Clinton, and this President Bush. And President Clinton's Justice Department was, not particularly any better on these kinds of issues. I mean, there's just, politicians, particularly when you're talking about foreign nationals' rights, politicians are just not, there's no votes there. There's no votes there. So, which is why it's so critical that there be judicial protection, I think. And so critical that there be groups that really do commit themselves to human rights and to these kinds of rights, and so critical that we all, support those groups and work with those groups. Yeah.
As I was listening to your talk, I was thinking a lot about the conflicts that are going on in Iraq and Afghanistan, and maybe possibly in the future in Iran. And I think you mentioned these things kind of throughout your talk. It seemed to me there's a lot of parallels and similarities between these domestic detentions and some of the things that are going on in the Middle East. The U.S. is doing not only things like Abu Ghraib, but some of the rhetoric about these supposed terrorists and sort of this deception of the public. And I was really curious to speak a little bit about that.
Well, I mean, they're definitely it is part of a larger picture, I think, and I think in some ways it's driven by what again we keep coming back to John Ashcroft. My favorite line about John Ashcroft was David Letterman, who said that John Ashcroft resigned so he could spend more time spying on his family. But John Ashcroft coined this phrase, the paradigm of prevention, as, this is what we're going to do after 9/11. We're going to prevent the next terrorist attack from occurring by using aggressive, coercive means, not to hold people responsible for what they've done in the past, but to stop people from doing things that we fear they might do in the future. So that's why you get preventive detention, coercive interrogation, which is always justified on the ground that we're going to stop the ticking time bomb from going off and the like, always future-oriented. And you get wars like Iraq, right? I mean, the Iraq War was justified on the ground that, you know, the argument was made by the Pentagon in the National Security Strategy document of 2002 that the law of war, which says that a country cannot attack another country except when it's been attacked, so in self-defense against an armed attack, or when it faces an imminent armed attack. Those are the only justifications for a country to unilaterally use force against another country. Well, the 2002 National Security Strategy said, well, that's not enough. In an age of global terrorism and weapons of mass destruction, we have to be able to act against gathering threats, against non-imminent threats. And so we can engage in what's called a preventive war. And that's what got us in, that was the justification for getting into war, into Iraq. We didn't argue that Iraq had attacked us. We didn't argue that Iraq was engaged in an imminent attack against us or threat. It was that they might have weapons of mass destruction that might be given to Al-Qaeda at some point in the future and that then might be used against us. That was the argument. So I think it's this preventive impulse which drives a lot of it. And the rule of law is designed to limit the use of extreme coercion by the state to situations in which you can demonstrate that there's an objective basis for doing so. And when you start engaging in preventive, future-oriented, necessarily speculative uses of coercive force, like war, like detention, like interrogation, then you get into all of the problems that we have seen. So I think they're related in that way, and that's actually the subject of my next book, which will be out in August, which is called Less Safe, Less Free. And the subtitle is still in progress, but it's something like, the book has been written, it's just the subtitle, something like The Failure of Preemption in the War on Terror, or something like that. So thank you very much.
I'd like to thank David.
Thank you.
You've been watching Enemy Aliens and Constitutional Freedoms: How Double Standards Have Undermined Our Liberty, Our Character, and Our Security in the War on Terror. Our speaker has been David Cole. David Cole is volunteer staff attorney with the Center for Constitutional Rights and is professor of law at the Georgetown Law Center. He is the legal affairs correspondent for The Nation magazine, a contributor to the New York Review of Books, and a commentator for National Public Radio. His books include Less Safe, Less Free: Why America is Losing the War on Terror, co-authored with Jules Lobel. Enemy Aliens: Double Standards and Constitutional Freedoms in the War on Terrorism. Terrorism and the Constitution: Sacrificing Civil Liberties for National Security, co-authored with James Dempsey. And No Equal Justice: Race and Class in the American Criminal Justice System. For more information about the topics discussed in this program, please visit the Center for Constitutional Rights website at www.ccr-ny.org. This program was produced by pdxjustice Media Productions. To find out more about our work, please visit our website at www.pdxjustice.org. You'll find links to our many other programs, including lectures by Phyllis Bennis, Rashid Khalidi, Noam Chomsky, Natalie Angier, and many others. Thank you for watching, and thank you for supporting listener-sponsored radio, public access cable television, net neutrality, and all forms of grassroots, democratic, community media.
Who was a real hero of the time. He was the head of he was the Secretary of Labor, which at that time was in charge of immigration, and he actually stepped in and overturned many of the deportation decisions because he felt that these so-called Palmer raids were so problematic, and was ultimately called up on impeachment charges for doing so. He wrote a book about this period, and he said that the delirium caused by the bombings turned in the direction of a deportation crusade with all the spontaneity of water seeking out the course of least resistance. With all the spontaneity of water seeking out the course of least resistance. And what he meant by that, of course, was that the reason that the government singled out foreigners and rounded up foreigners was not because there was evidence that foreigners were the bombers, but because they could. Because they could employ tactics like guilt by association, because they could deny people access to lawyers, because they were them and not us. And I think in the wake of September 11th, again, we have seen our government pursue this course of least resistance. And in a way, it's understandable. You know, one of the things that democracies do. Democracies are good at a lot of things, but they're not very good at protecting those who are not in the majority. And it's very tempting when the majority is threatened to try to figure out some way to reassure itself, not by sacrificing its own rights for greater security, but by sacrificing somebody else's rights for greater security. And that's, in fact, what the Bush administration essentially laid out to the American people. They said, you don't have to give up your rights for a promise of greater security because we've got a better deal. We'll take away their rights, they being foreign nationals and especially, of course, Arabs and Muslims, for your security. So what I want to do this evening is just sketch out the multiple ways in which this double standard has been exploited in striking what I think is an illegitimate balance between liberty and security. And then I want to make 3 points about this tactic, this exploitation of double standards. First, that it's wrong as a normative matter. Second, that it's a first step towards the evisceration of rights of all of us, including the citizens among us. And third, that it's counterproductive as a matter of security. So first, let me review for you the ways in which these double standards have been employed. I think you really have to start with what I call the Ashcroft raids, you know, in reference to the Palmer raids. After 9/11, John Ashcroft made a speech in New York in which he said, I am going to use every law within my power, especially immigration law, to lock up suspected terrorists, keep them off the streets, and prevent the next terrorist attack from occurring. And he did. In the first 2 years after September 11th, according to the government's own admitted numbers, over 5,000 foreign nationals were locked up in preventive detention immigration measures. Over 5,000. Many of these people were locked up in the first couple of months after 9/11, as the FBI and the INS swept out and picked up people on no charges or on immigration charges, on some, not on any strong basis that they were involved in terrorism, but on some concern. The Office of Inspector General of the Justice Department did an investigation of this roundup after the fact and found in its report that the people were locked up on such information as an anonymous tip received by the FBI that there are too many Middle Eastern men working at the convenience store down the street. That was the information they get. And now before 9/11, they get that kind of information, they'd say, thank you very much, hang up the phone and go back to their work. But after 9/11, what they did was they sent out the FBI to the convenience store, lined up the Middle Eastern men who were working there against the wall, and if they couldn't rule out that they were terrorists, they locked them up. They locked them up. And they were then part of the statistics that John Ashcroft used when every time he got on television and said, we've now locked up 800 suspected terrorists. We've now locked up over 1,000 suspected terrorists in the 9/11 investigation. He stopped giving a Thank you. Thank you for that very nice introduction, Clay. Thank you to the Diversity Committee for organizing this event. It's nice to be here. The first time I was in Washington State was about 27 years ago, the summer before I went to law school, and I was hitchhiking from Seattle to Salt Lake City with a friend of mine in the back of a pickup truck when we looked over and we saw this big smokestack, and it kept growing higher and higher and higher, and it was Mount St. Helens going off. So that was 27 years ago. Then I didn't come back for about a dozen years. I came back 15 years ago, about 3 weeks before I was to get married, with my wife and another couple, and we were going backpacking in the Cascades mountain range. And on our first day out, we were caught in a whiteout snow blizzard, and the second day we were crossing a kind of straight up and down ice field, and roped together, fortunately. And first I fell, and then my friend's wife fell, and then my friend who was leading the expedition decided maybe we weren't up to it, and we left and went somewhere a little bit safer. So I feel relatively safe this time. Bola drove me here from the airport. That was a little scary, but other than that, I have a lot of microphones on here. I understand that, a couple of years ago, John Ashcroft came and spoke here and insisted that he not be taped at all. His position is that he wants to tape you, but you can't tape him. All right. This is not the first time that the United States has faced a threat of terrorism leading to acts of horrific violence. In an earlier stage in our history, 1919, we were confronted with similar acts, not of the same scale, but similar acts. 1919 was a period of substantial crisis in the United States. There was the war had ended, the veterans had come home, there weren't jobs available for them, there were strikes across the country, many of them turned violent. The communists had taken over the Soviet Union, and all of this culminated on a single day, within the same hour, in 8 different cities. In the summer of 1919, bombs were set off. One of them blew off the front of the private home of the Attorney General of the United States in Georgetown, Washington, D.C. A. Mitchell Palmer was his name. And we responded to that series of attacks and that threat in a way that I think is illustrative of the way that we have responded to the attacks of 9/11. The government did not go out and find the bombers and bring them to justice, but instead went out and rounded up thousands of foreign nationals in coordinated raids carried out in 33 cities across the country. Locked them up, denied them access to lawyers, interrogated them coercively, and ultimately ordered many of them deported, not for any involvement in the bombings. No bombers were actually ever brought to justice, but instead on charges of technical immigration violations and guilt by association with one or another branch of the Communist Party. And writing about this period after the fact, Lewis Post, number after it reached about 1,100, and people started saying, how come none of these people have been charged with a terrorist crime? So then they announced, well, it's too hard for us to count how many we've locked up, so we're not going to tell you a number. But over the first 2 years, it was, by the government's own admissions, over 5,000. Many of these people were picked up and locked up without charges. So you're picked up off the streets of the United States, you're thrown in detention, and you say, why am I here? And there's no answer, because there's no charge. They locked them up first, looked for a charge later. They were arrested in secret. So a woman could find that her husband has not come home that night, and she could call the local police, she could call the FBI, she could call the INS and say, do you have any record of my husband? He's disappeared, he hasn't come home. And the answer would be no, even if he was sitting in jail right behind the man on the phone, because the arrests by order of John Ashcroft were all secret. Many of them were eventually charged with some sort of immigration violation, taking too few credits on a student visa, working without authorization, overstaying your visa, things like that. And all of those were tried in secret trials, closed to the public, closed to the press, closed to members of the family, closed even to members of Congress. John Conyers, the representative, now the chair of the Judiciary Committee, sought to attend one of these hearings in Detroit, and he was barred at the door. Many of these people did, in fact, violate their immigration status and agreed that they violated their immigration status, and were allowed by the judges in those cases to leave. We're told you can leave. Ordinarily, that would be the end of the case, because the only legitimate purpose of an immigration case is to remove people who are not properly here. But when your purpose is not to remove people who are not properly here, but to lock up people who you suspect but have no evidence of engaging in some sort of terrorism, it's a problem if they agree to leave. And so the administration adopted a policy called hold until cleared, under which you were not allowed to leave the country, even if you agreed to leave, until the FBI satisfied itself that you were not, in fact, involved in terrorism. That took the FBI, on average, about 3 months, in many cases, more than 6 months. And people just sat in jail on no probable cause.